Hello students, welcome to the Global Online. In this session, we will solve CLAT legal reasoning previous year passage and MCQs step by step. You will understand how to read a passage, identify the legal principle, and apply it correctly to the question. Let's begin and improve your legal aptitude for CLAT 2026. Our new CLAT 2026 batch starts from 10th of November. Join now to get live interactive lectures, topic-wise notes, full-length mock test, and expert guidance for your complete CLAT preparation. Start your journey towards the success with Global Online. So let's begin with the passage. The Supreme Court of India declared that the right to privacy is a fundamental right and that the right to informational privacy is part of this right. Subsequently, the Parliament of India enacted a new law relating to digital personal data protection. The law applies to Indian resident and businesses collecting the data of Indian resident. It also applies to the non-citizen living in India whose data processing is in connection with any activity related to the offering of goods or services that happens outside India. The law allows personal data to be processed for any lawful purpose. If the personal data is sensitive, then additional safeguards are to be observed. The entity processing data can do so either by taking the concerned individual's consents or for legitimate use, which include a situation where an individual has voluntarily provided personal data for the specified purpose. The law requires that an individual's consent must be free, specific, informed, unconditional, and ambiguous with the clear affirmative action. And for a specific purpose, the data collected has to be limited to the necessary for the specific purpose. A clear notice containing these details has to be provided to consumers, including the right of the concerned individuals and the grievance redressal mechanism. Individuals have the right to withdraw consent if consent is the ground on which data is being processed. The law also creates rights and obligations for individuals. These includes the right to get a summary of all collected data and to know the identities of all other entities organization with whom the personal data has been shared. Along with a description of the data shared, individuals also have the right to correction, completion, updating, and erasure of their data. Besides, they have a right to opt in redressal for their grievances and a right to nominate persons who will receive their data. So let's summarize this passage. This passage explains the key provision of Indian Digital Personal Data Protection Law enacted after the Supreme Court recognized privacy as a fundamental right. The law governs how the personal data of individuals in India is processed. It mandates that data processing must be for a lawful purpose and require entities to obtain a clear, informed, and specific consent from individuals except for certain legitimate use. The law emphasizes transparency through clear notices and grant individuals significant right, in, including the right to access, correct, and erase their data, the right to know with whom their data has been shared, and the right to grievance redressal. So let's discuss questions. An Indian company collects personal data from its user to provide a personalized service. The company intends to share this data with the third-party vendor for targeted advertisement under the Digital Personal Data Protection Law in India. What must be company do before sharing the data? So first we have to understand the question. The question is asking for the primary legal prerequisite for sharing users' personal data with the third party for new purpose, that is targeted ads. So the passage states that the law requires that an individual's consent must be free, specific, informed, unconditional, and unambiguous with a clear affirmative action and for specific purpose. Sharing data with the third party vendor for advertising is a new specific purpose that was not part of the original consent for personalized services. Let's see what are the options here. Option A is obtain explicit consent from the users. This one is correct since the purpose is new and specific. The company must obtain a fresh explicit consent as defined by the law. Option B says share the data by informing the users that it is for business purpose. This one is wrong. A mere notification is insufficient. The law requires explicit consent for such actions unless it falls under the narrowly defined legitimate use, which is scenario does not clearly state. So option B will be wrong here. In case of option C, encrypt the data and share it with the third party vendor. This one is also wrong. While encryption is a good security practice, it is not the legal prerequisite for sharing the data. The law's first requirement is legal basis for processing, such as a consent. While in case of option D, inform the third party vendor that the data is sensitive. This one is wrong. This is irrelevant to the legal obligation toward the users from whom the data was collected. So the question focuses on company's duty to the users. So out of all this option, as we discussed, option A will be the correct, because since the purpose is new and specific, the company must obtain a fresh explicit consent as defined by the law. Let's move to the next question. A social media platform processes users' data based on the consent given during account creation. A user now wishes to withdraw consent to process their data under the Digital Personal Data Protection Law in India. What must the platform do? So first see what is asked in this question. This tests your understanding of the user's right to withdraw consent and the corresponding obligation of the data processor. So the passage explicitly states individuals have the right to withdraw consent if consent is the ground on which data is being processed. So let's look for the correct option. Option A says refuse to accept the withdrawal request since the consent was already given. This one is wrong. This directly violates the fundamental right to withdraw consent granted by the law. Hence option A will be wrong here. In case of option B, comply with the legal requirement and stop processing the data, this one will be the correct. The right to withdraw consent is a meaningless without a corresponding obligation to stop processing. So withdrawing consent removes the legal basis for the processing. While in case of option C, continue processing the data but notify the user, this one is wrong. This is the opposite of what the law requires. Processing must stop upon withdrawal. In case of option D, allow withdrawal only after 30 days. This one is wrong. The passage does not mention any mandatory cooling off or waiting period for withdrawing a consent. Hence, option B, comply with the legal requirement and stop processing data, will be the correct answer here. So let's move to the next question. A financial institution collects biometric data from its client for verification purpose. If the client wishes to know what data has been collected under the Digital Personal Data Protection Law in India, what right allows them to request this information? So in this case, you need to identify which specific right empowers an individual to ask for a summary or a details of the data that has been collected about them. So the passage lists the right, including the right to get summary of all the collected data and to know the identities of all other entities or organization with whom the personal data has been shared. So let's look for the correct answer. Option A says right to data portability. This one is wrong. The passage does not mention a right to port or a transfer data to another controller. In case of option B, right to correction, this right deals with the correcting inaccuracies, not initially accessing what data exists. It will also be wrong. In case of option C, right to access, so the right to get summary of all the collected data is classically known as right to access in data protection regimes. Hence, this one will be the correct answer here. In case of option D, right to be forgotten, this is related to the right to erasure, which comes after one has accessed and reviewed the data. Hence, this one will be wrong. So the correct answer will be option C, right to access. Let's move to the next question. A startup provides a health tracking app that collects sensitive health data from users under the Digital Personal Data Protection Law in India. What additional precautions must be startup tech compared to regular personal data? So in this case, this question checks your understanding of the heightened protection required for the sensitive data compared to the regular personal data. So the passage itself states, if the personal data is sensitive, then additional safeguards are to be observed. So in case of option A, no additional measures are needed. This is directly contradicts the explicit statement in the passage, hence it will be a wrong option. In case of option B, ensure explicit consent and adopt higher security standard. While not itemized in this passage, this is the logical and legal implication of additional safeguards. It implies a stricter standard for a consent and stronger security measures to protect the sensitive nature of the data. Hence, this one will be the correct answer here. In case of option C, store the data only with the government agencies. The passage does not mandate any specific storage location like a government agency. Hence, option C will be wrong here. In case of option D, store the data only with the hospital. So similarly, the law does not restrict storage only to the healthcare institution. Hence, this one also be wrong. Hence, only option B will be the correct answer here. Ensure explicit consent and adopt higher security standards. Let's move to the next question. As per the passage, what are the rights included under the Digital Data Protection Law of India? 1. A right to get the summary of collected data. 2. Right to know to whom the data has been shared. 3. A right to correct and update the data. 4. A right to get the data removed from the database. 5. A right to decide on who can receive their data. And 6. Right to get a redressal of grievances. So this is a comprehensive check to see if you can correctly identify all the rights explicitly listed in the passage. So let's verify each number against the text. So first one is right to get summary of collected data. It is explicitly stated. Second one, right to know to whom the data has been shared. It is also explicitly stated. Third one is right to correct and update the data. This is also present in the passage. Fourth one, right to get data removed from the database. It is also mentioned in the passage. Fifth one is right to decide on who can receive the data. This is also stated in the passage. Right to nominate person who will receive their data. Sixth one is a right to get redressal of grievances. It is also stated in this passage. Hence, option D, 1, 2, 3, 4, 5 and 6 correct. All 6 are directly mentioned in the passage. So that's all for today's legal reasoning PYQ session. If you found this helpful, make sure to like, share and subscribe to Global Online. For more CLAT preparation videos, keep learning, keep practicing and see you in the next lecture.